and I
This
still.
meeting is being recorded.
It's giving us like recording notices. Okay. Are opponents ready? Judges ready? Okay, thumbs up. I'm seeing thumbs. Okay, well, if everyone's ready, hi, my name is Corwin Gauna. Again, I will be the first and third speaker for the affirmation from El Cerrito. The resolution is this House, as a new country adopting a constitution for the first time, would include a right to trial by jury. So is it okay if I do a quick off-time roadmap?
I would just get into it, maybe.
Okay, yeah. So just, I guess, throughout my speech, I'll be giving some contention, some top of case, the affirmations plan, etc., the basics. With that being said, I will start my time now. So firstly, as this is a policy round indicated by would being in the resolution, we believe that this should be weighed on net benefits. So basically, whether or not adopting a constitution for the first time in this new country is a good thing in general for the people of the country and just in general. And so to get onto some definitions, we would like to define a trial by jury as a body of people, which is generally 12, like 12 people, who are sworn to give a verdict in a legal case on the basis of evidence submitted to them in court. And we would also like to define a constitution as just a set of fundamental laws that govern a country. We think that both sides will agree on the general sentiment of what a constitution is. Yeah, go ahead.
The body of 12 people, are they like any people, or like are they just random citizens you select?
Yeah, they're just people selected from the populace, basically.
So citizens,
Yes, citizens.
just
Yeah.
citizens. Okay.
Does that answer your question?
And it's like by chance to remove bias, like from like getting from you, right?
Yeah.
Okay.
Okay. I will resume my time now. So to get into the affirmations plan, we believe that firstly, the actor for this plan, as stated in the resolution, is just a new country who is adopting a constitution for the first time. And we say that this country is like generally reasonable according to like how we view society. So we say that the timeline is simply whenever this constitution is written, because of the resolution, we see this constitution is being written whether or not the jury thing is included. And so the timeline is just dependent on whenever that constitution is written. And so for funding, it's just normal ways and means. The plan itself is to include the right to trial by jury in serious criminal cases, so involving like 6 months or greater of imprisonment, and also in civil cases involving questions of law, so relating to monetary damages, but not of like equity. So basically what we mean is in criminal cases with serious punishments, the right to trial by jury is provided. Additionally, in civil cases involving like a monetary suit, basically, so where one side is having monetary damages, this right is extended as well, but not in like equity settings. So for example, a divorce. And so this is basically what we see with the United States jury system. And then another observation before I get into contentions is that questioning and like selection is basically conducted by judges and attorneys involved in a case before the case. This is called voir dire, and it is to ensure like an impartial jury. So first contention from the affirmation then is on the promotion of democracy. And so I would like to break this down into two sub-contentions. The first sub-contention will be participation. And basically what we mean to say is that by participating in a legal process frequently, this ends up giving more power to the people. And so when we think about a democracy, the fundamental basically tenets that a democracy is built on is that the voice of the people is exercised through the government. And so we see that the jury is a direct representation of the voice of the people because it is literally the people. So through this, then we see that by having a jury be able to represent this society's voice, we see that this in turn shifts power away from the government and to the people. And so firstly, on participation, we say that participating in the government is just a good thing in general, because again, like I just said, democracy, like the whole point of it is to ensure that the people are having their voice be heard. And so simple impact of this then is that we see people have more political autonomy because they are more involved in their government. Additionally, we see that the preservation of like the general populist voice and basically the interests of the general public is just good for net benefits because we are serving the greatest amount of good to the most amount of people by letting their voices be heard. And then second subcontention then is pretty similar, but it is basically just on checks to government power. And so what we mean to say is as the power of the people increases through their voices being heard, fundamentally there is a shift where the power of the government decreases. And so what we say is that this is directly in the interest of like democracy and is good for the people in general. So a lot of problems that we see in the modern day relating to like government issues and the reduction of social welfare of a group of people, like a country, say, are usually results of the government having too much power and then unfairly exercising that power. And so like an example that I'll just bring up is let's say a hypothetical government has, and this isn't really related to the topic, but it's an example of government power. Let's say that a government has the ability to raise taxes. And so they raise these taxes and then spend that tax money on, let's say, I don't know, building a ballroom for the government. And so we can say that this is bad for the people because we are taxing them, taking money away from them, and this basically harms them because they're losing additional money and that money is not being reused to help them. All of that is to say that fundamentally the government is meant to serve the people, but in many cases the government does not serve the people. And so what we see then is that the people should be the ones having the power basically to make decisions relating to the law. And so fundamentally, to bring this all back to the jury thing, what we see is that when legal basically decisions are made by a group of people who represent the populace, those decisions, are more likely to basically reflect the voice of the people and not the government. And so by checking the government's power, we say that this is just uniquely a good thing for this society. And then, sorry, I forgot to mention there will be a third subcontention to contention one, which will be on education. And so what we mean to say is that essentially, when you go to a courtroom and participate in a jury, you are learning actively, like hands-on, about the law because you are being advised by the judges, you are seeing the court process. And in general, we say that this is a good thing for society because we want the people of a governed country to understand how that country is governed. And so we say that the understanding of the government running a country results in people having more power, both in terms of like intentionality of making decisions as well as just general knowledge. And so we say that this is the education of the people is a good impact of having juries in trials. So second contention then will just be on the dilution of bias. So fairly simple link here. We see that with a group of people who are basically designed to be impartial, as I mentioned with the voir dire thing, where there's a very like scrutinized, I don't know what the word is there, but there's a very scrutinizing selection process that ensures that jury members aren't hateful or biased, etc. And so because of this, we simply see that there is an elimination of bias. Number one, because there is a larger group of people that are involved in the decision-making related to the trial. And this fundamentally, we say that more perspectives leads to a decrease in bias as the decision being made is not coming from one biased perspective. But we also say, in general, this selection process just really results in a basically less biased process. So overall, for the reasons of the promotion of democracy involving participation, checks to government power, and the education of the people, as well as the reason of dilution of bias in a courtroom, I strongly urge a vote for AF. Thank you.
Thank you. Okay. Now, is everyone ready? My time will actually, yeah. Thank you, y'all, for being here. Thank you, judges. Thank you to my partner. My time will start on 3, 2, 1. Now, first on analyzing the burden of this debate, as the opposition, we only have to prove that by jury is bad, right? Right to trial is fine, but by jury is not good for the country. And definition of the jury, the opponents gave a pretty fair and obvious definition of the jury. But we would like to offer a counterplan. We offer a panel of appointed judges by a separate governmental branch that handles this issue, and let's assume that governmental branch is made up of elected officials. Additionally, let there be 3 judges per trial, just like this debate round, right? If it's good enough for us, it's good enough for another country. This isn't a new thing, right? Germany, France, Belgium, Norway are already doing similar things, so don't let them call this abusive because this is very logical. we also agree with their characterization of this
Point of
jury as a
clarification.
judge. POC?
Uh,
You're muted.
Sorry, is the panel of judges that you mentioned in your counterplan, is that the 3 judges per trial, or is it a different thing?
It's the 3 judges per trial. Like instead of like your jury and like 1 judge thing, you just have 3 judges.
Okay, thank you so much.
It's very similar to like I think especially Norway's system, if you're more familiar with that one. But
Okay, thank you.
I'm gonna resume time at like what 40 seconds. Okay. No, we agree with the characterization of that this only applies to criminal cases with serious punishments and civil cases, which actually ends up helping us in the end. They also say, oh, questioning a selection is conducted by judges, but again, we want to make sure that we all know that screening is always imperfect. They can't perceive implicit hidden biases, especially in a country with a lot of those implicit or like imperceivable biases. I'll expand on this later, but now going towards my first contention, which is conflict within jury. What are we? We are a new country, which means we most likely came out of a revolution or a civil war. This means that there's probably a drastically different like division in opinions among the populace, which means implicit bias indetectable by the jury and questioning and screening is probably going to be all over the place. For example, Jim Crow courts back in the Civil War era, well, after the Civil War era of the United States. Now, the crucial thing we need to answer is why are judges less biased, right? We give you 3 warrants. First, because they're trained to do so, because they're literally trained as a judge. Second, they're selected out of the they're selected out of the populace to be the most unbiased of those people. It's much harder to select a random group of 12 people and expect those 12 people to be not have implicit biases even after screening than to do that with 3 judges, right? And third, they can easily be held responsible if they make terrible decisions. Well, jury has jury protection. If they make like terrible biased decisions, then we can't do anything about it. What is the impact here? The impact is that it hurts the minority. Biased views gets passed along. If the jury happens to be just by chance to be swayed by one side by those implicit biases, then oh no, the minority continues to get oppressed, which means their lives continue to get worse. Now, on to contention 2, which is lack of expertise. A few warrants here. First of all, this is a new country. Again, usually that means it's developing. Thus, the majority of citizens are most likely, unfortunately, not able to take privilege in taking part of quality education. This poses a problem. This means they probably have to be explained everything by prosecutors and defendants, many of which will attempt to delude them with complicated terms or false mathematics or statistics. We see this very often, especially in civil cases. Like, oh my God, this person has a 90% chance of blah, 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 but it's just manipulating mathematics. As a jury without such privileges would be incredibly hard for them to identify what is real or what is not. And second of all people who don't study law or philosophy lack expertise in the rules of evidence. This doesn't matter whether it's a new country or not. They rely on narrative heuristics, no matter education level. Third of all, these jurors are new to the situation. They have basically no idea what's going on, and they have to be caught up really fast, or else they will be confused. And this confusion, again, leads to less impartial decisions or less fair decisions. And let me go into some impacts. First of all, you have terrible efficiency. Why? Because you got to teach the jury everything. What does this mean? People don't get a speedy trial. Many people will have to wait in jail. When they wait in jail, they can't work. They can't support their family. They can't help. Even if they're innocent, they're being punished because they have to wait for the judges to choose of 12 people that are magically the 12 people, right? And they have to screen them, and those 12 people have to be caught up on everything. And second of all, incorrect judging. I mentioned this before, but a new country is often divided along many tensions, which can lead to ethnic, religious, political biases. And these biases are incredibly hard to detect because they're often implicit. And again, juries, like people in a jury would obviously say they're not biased, even if they are, because they obviously don't want to be seen as a racist. Ultimately, judge, here are the impacts. With biased decisions, bad people will go free. And third, a resource drain. The most important thing in a brand new country is money, time, human capital, right? Every dollar, every hour spent on the legal system is a dollar or hour not spent on building the infrastructure we need. For example, hospitals, schools, roads, all of these things come before a legal system, especially if you're only talking about serious criminal or civil cases, right? These cases are usually pretty easy to identify. I'll talk about this in my rebuttals. Think about it. How can you ask a juror to go into a courtroom where there's no and also without infrastructure, it's also really hard to find the jurors in the first place, right? If there's no room or roads, or there's no distribution system or no mail system, you can't really find your jurors in the first place. right? And you're also going on the jurors without pay. They're doing all this without pay. Running a jury trial is very expensive, and that is terrible for a new country. With 3 judges, though, oh, well, they're professional judges. They get paid. They don't waste their time because they're professional ones. We don't lose out on other stuff in other sectors of the country, especially also because they're 3. This opportunity cost is really large, and this will actually lead to less money being spent into innovation. And now C3, a small contention, right? And this is something we can probably all relate to. This is really annoying for jurors. Small contention, small impact. Having trial by jury means you will have to go to the juror, which disrupts normal people's lives, which is annoying for everyone, right? You have to sit in a room for hours on end, and you have to feel guilt if you don't make the right choice. Now, moving into rebuttals on the opponent's case, on their first contention, which is promotion of democracy. Now, we want citizens to shape the society, but why is trial by jury specifically is going to do that? Like, the opponents don't really tell us. My first response is, again, bias and expertise. Really, when you think of it, the people offer nothing unique. Gov made it pretty clear, heavy criminal cases or civil cases. There's usually really clear laws. Murder is illegal, right? The jury doesn't actually do anything. We just need people to see if the evidence is convincing, right? The jury doesn't offer anything unique. And response 2, participating in the government. They tell you that it's a good thing in general, but sure, it's a good thing if you're voting, but this particular participation doesn't actually link to the things they tell you they link to. There are no warrants in the impact. We want the government to represent the people, but we don't want the people to do the job of the government because, again, that serves no purpose other than wasting time of the people and creating for more biased and less impartial like trials, right? Now, on to their second part of their first contention, checks to governmental power. One response, well, 2 responses. First is alternatives. There are a lot of checks to governmental power that are possible. For example, the United States takes a 3 branches: executive, judicial, and legislative. And a lot of them involve people actively involved in the government. And response 2 is probably the most obvious one, because the government literally told us that the jury is only there for heavy criminal cases and civil cases and not equity cases. This isn't like the Supreme Court. You won't be checking the law. You will be just saying, is this person guilty or not? And on to their third part of their first argument, which is education. 2 responses. First of all, this doesn't really make sense because deciding between a person guilty or not doesn't lead to you knowing how the government works. And second of all, this is massively non-unique because educational facilities, schools, history classes exist for a reason. They would be much more efficient. And by having people here, you're actively impeding these permanent institutions from being built. And on their second contention, my partner will talk about it, but I'll quickly go over it with a 1-sentence response, which is it's simply impossible to delude bias completely, especially if you're choosing 12 random people. And if you want to do that, then you have other impacts that go into our case. With that, I urge a ballot. Thank you. Opponents, hello.
Yeah, sorry. Okay, so again, my name is Ezra Hellman. I will be the second speaker for the affirmation on this round. Quick off-time roadmap. First, I'll address the counterplan of the opposition. Then I will move on to responding to the contentions of the opposition. And finally, I will defend the affirmations case. So with that, yeah, my time starts now. So in response to the counterplan of the opposition, let's review what this counterplan is. It's basically to, instead of implementing a jury of 12 randomly selected citizens, we implement like a group of 3 judges per trial. And they cite that this is seen in several European countries, so it's like not a new system. But again, I want to like kind of bring it back to the affirmation second contention, which was not super heavily responded to by the opposition, which is that if we have more people making these decisions, then it is less likely for like extreme biases to occur, because biases are reinforced by the individual. So if we have more people discussing it and mulling over these decisions, then ultimately we see like bias diluted by a factor of 4, because our plan includes 12 jurors, the opposition's plan only includes 3. Now, moving on to the first contention of the opposition, which is conflict within the jury. They preface this contention by saying that if this is a new country, this means there's going to be political polarity and chaos. But our primary response to this idea is that judges are going to be biased as well. And so if judges are few and only representing like certain interests, then we see that they're only representing like one side of the political coin. So if we have extreme polarization, then we want to represent both sides so that we can come to like a more equitable conclusion to these cases. In the opposition's plan, we have only 3 jurors that are probably influenced by like the federal government and influenced by their own personal views. And ultimately we see like more bias and more like extreme decision making that may not be in the interest of the people, or what like the average opinion of the average citizen is. So in this contention, they also outline that like that judges are going to be trained, and that makes their decision making like more informed, whereas juries are like, you know, made up of less informed people that aren't as familiar with how these systems work. However, in the affirmations plan, during these trials, there will still be judges and like trained professionals present to help advise the jury on like law specificities, essentially. So what we see is that in both worlds, informed decisions will be made, because people that understand the law and its functions and how it works are going to be present to let the jury make its decision. But ultimately, we want to remember that in these trials, like subjective decision making is made as well. It's not all objective. So this is like the purpose of a jury, is so that they can become informed, and then based on the information given, the necessary information given, they can make what they deem the right decision. So for that reason, the affirmation, yes, I'll take your POI.
So you're saying you're going to like give the jurors information and like teach them stuff, right? Like during the trial or like before?
So before and during the trial, the jurors will become educated on the given topic and what they need to know, yes. This was outlined in my partner's first speech as well. So now let's move on to the second contention on lack of expertise, which is pretty closely tied to what I just responded to. Basically, the point here is that like in this country, citizens probably can't participate. Like one big point is that citizens can't participate in like good quality education, because understanding laws is like hard and challenging, and also we're in like a new country, right? So 2 responses. One is we're drafting a constitution for a country that we hope will exist for a while. So like the opposition's case like is all about how this will start off with chaos, but we want to think about long-term benefits as well. For example, like this system is very similar to the United States justice system, with the juries and stuff. And the United States has existed for hundreds of years. And since this round is being weighed on long-term benefits, we also want to think about the impacts of having the right to jury, trial by jury in a country that has existed for a while. We're not just thinking about immediate short-term benefits, we're thinking about long-term benefits. Additionally, on this idea of education, this is kind of like a turn, because once again, like our third sub-contention on our first contention is about how this is a hands-on experience that teaches jurors about the systems of government, about how the justice system will work in this given country, which is a good thing because it means more power to the people. They're more educated and less susceptible to like being manipulated. And we see that in the affirmations world, people have more autonomy. The ordinary citizens have more autonomy. Now, the opposition also says that like in this contention that the jurors are like new to the situation and they're not as informed. The entire point of trial by jury is so that, or not the entire point, but one major point of trial by jury is so that jurors can become informed. So like additionally, judges aren't going to be informed on the specificities of like certain cases, like a criminal case. Each criminal case has its own situation, has its own like conditions and story. And so the point of having a trial is so that the process of discovery can happen, so that those making the decisions, whether it's a judge or a jury, can learn. So ultimately, the trial is meant to inform the jurors. And what we see in the affirmations world is that we have ordinary citizens learning about these cases and making informed decisions because the entire system is meant to allow them to make informed decisions. The third contention of the opposition is not a very big one in the scope of this round, but I'm still going to respond to it. It's just about how it's like annoying for jurors. First, like the opposition kind of conceded, this is a pretty small impact. But second, it's more annoying for jurors not to understand, for like ordinary people not to understand how a government in which we assume they will be participating in through democracy actually works. And so giving them this hands-on process allows them to understand the court so that if they ever like in an extreme case get convicted of a crime, they know more about that system. Now let's move on to the affirmations case. So in response to our first sub-contention of our first contention on the promotion of democracy, this first sub-contention is like participation in government affairs. The opposition says that we provide no warrants, however we do, and also that people shouldn't be doing the government's job. So this doesn't really respond to the impact or the warrant of this sub-contention. Like, more power to the people will like objectively result from giving the people the opportunity to participate in juries and make these important decisions. So it isn't really the government's job, because in this round we're defining what the government's job is. And in the affirmations world, the government's job is to provide a judge that can inform these jurors on like what it is that they are meant to do and what like the laws are objectively. Now, in response to our second sub-contention on checks to government power, the opposition says that the jury is only there for criminal cases, but this doesn't really respond or interact with my partner's analysis on like more power to the people in these cases means less power for like government officials, like judges, and etc. In response to our third sub-contention on education, the opposition says it's non-unique, history classes exist, but this provides a hands-on experience that is way more educational than any history class. In response to our okay, I'm going into grace time now. In response to our second contention on dilution of bias, the opposition says it's impossible to dilute bias completely. However, it's also impossible to dilute bias in judges. And so ultimately what we see is that a bigger jury means less bias because it is diluted, like my partner explained. So for all these reasons, I stand strongly with the affirmation. Thank you.
Okay. My name is Jane Hu. I'm going to be the second speaker for opposition. I'm going to give a quick off-time roadmap, if that's okay for everyone. Basically, I'll be going top of case, kind of just like a little summary of what's been going on throughout this entire round. I will start by addressing the government's case, and then I'll move on into our case, the opposition side. With that, time will begin on my first word. Judge, let's go back to the very first speaker. They give us a few definitions, a few that which we agree. For example, timeline, we agree whenever this constitution is written. However, what they say is trial by jury, and it's a body of people who are picked by chance, as my partner asked in a POC, right? Please remember this. These people come from a country that is new, which means that the people who are picked by chance have a very high probability that they just aren't as educated, right? And we also see this because, new countries need to build new infrastructure, which is one of the most important things. I think this goes unrebutted throughout our entire second speaker on their side. So we have to keep that in mind. These jurors are not as educated as we expect them to be. Moving on, they also talk about funding. They say normal ways of means, right? There's no explanation as to what normal means because one, this is a new country. We don't really have an example of what this new country would look like. So they don't provide any what funding would look like to begin with, right? But what we're going to tell you is that they just don't have enough money, okay? We think that this is a new country, and a new country is relatively, unstable in certain aspects. Hence, they're adopting a constitution for the first time, right? This is how unstable they are to begin with. And therefore, they clearly don't have enough money if they're a new country, right? And then moving on to our counter plan, they say that if we have more people, it's less bias, and they just basically refer to their second contention. But that's simply not true. My partner has already rebutted this. I will continue to do so in my speech later on. Jurors are civilians and citizens, not professionally trained judges. Judges, if you think about it, if you have bad judges, then you're basically doomed to begin with on government side or opposition side, right? But what we're telling you is that these judges are good. Okay, them saying that, oh, these judges are bad and they're just not good, literally makes it bad for both sides, except their side is even worse off because we tell you that them having jurors just makes it ultimately much more biased. Okay, and then they also tell you how moving on with their first contention, which is promotion of democracy. But let's move on to their first subpoint, which is participation. Sure, we agree, more power to the people. But the question is that necessarily better for this new country? The answer is ultimately no, okay? This isn't what they need now. What they need is what my partner mentioned. They need schools, they need roads, they need hospitals. These are the things that they need ultimately. Because if you can't live, how can you have rights, right? You need to be able to survive first before you can have these rights. Okay, they can also get power in different ways, like voting, okay? Just because you don't have a jury doesn't mean you automatically lose all of your democratic rights all of a sudden. That's not true. Voting still exists, and this is very, very important. So then their second speaker basically says throughout their rebuttals to my partner's rebuttals is basically we dropped their entire case. So one, let's point it out. My partner did not drop it at all. Okay, so anything that you say about them dropping, just ignore that. And moving on, I will further address these points as well. So let's talk about their second point, which is checks to government power, right? There are already checks to government powers. So just basically think about it. Checks and balances literally exist in a country. They have the judicial branch, they have the executive branch, okay, they have the legislative branch. These branches literally exist for a reason, right? And not right now. Each branch of the government checks each other. People don't need to check them through the judicial court, okay? They proceed to give you an example of how bad government power, but Judge, they give you this example of government being bad, but we don't really care because if they're spending money on useless things, that's the government's problem. And even if the jurors are in the judicial court, this will happen regardless if the country is corrupt and spends money on, useless things. This country will ultimately collapse in a general sense. And then on their own benefit, it was not be good at all. So when they bring up this example, just ignore it in the first place. Yes, I'll take your POI.
Sorry, my POI was, can you explain how the judicial and executive branch limit the power of the government?
Yeah, basically the checks and balances, they exist for a reason, right? So the judicial branch is supposed to check the executive branch just to make sure that they don't do anything wrong. So it works in a triangle. This is how the government system works. And we're assuming that this is the way it is because you guys keep bringing up the United States, right? Moving on to the third point, which is education. One, we're just going to straight up tell you education literally doesn't work, okay? You don't have money to spend on infrastructure for schools because you're focusing on paying the juries. And this response basically goes unrefuted throughout the our first, not right now, our second contention, which is lack of expertise, we talk about resource drain, which is our third warrant. And this is talking about how the jury needs to get paid. And if you're spending money on juries getting paid, then where are you allocating the resources to the actual things that we need in a country, right? And they also say it's a good thing for society because we want people to understand how government is being run. But why don't we just go to college, go to school instead of learning through courtrooms, right? What I mean? They're wasting time. You should be spending money on an actual school rather than expecting people to learn during jury duty. Moving on to their second tension, delusion of bias. They kind of say we don't really rebut this, but we do, and I will extend that more. They say it's just not, I'm going to tell you that it's just not possible, right? Once again, just go back to our second contention. We are a very new country, okay? Which means in terms of education, they're probably lower than already well-established countries. How can you expect 12 randomly selected people to be impartial, right? You can't because it's still very, very new. So given all of these things that we don't know what might happen in the future, we simply cannot just assume that there's not going to be any bias at all. There will be bias, especially if the country's unstable. Moving on, let's talk about our case, the opponent's case, the opposition case. Moving on to their first contention, which is conflict with jury. They say that judges are biased too. Well, I quote this. They say judges are biased too. Okay, we literally give you 3 reasons why as to they are not biased. They only refer to one of them. Okay, the first one we talk about, for example, we say they only try to mitigate one of those warrants, which is the training part. They say jurors will become informed and taught. But judge, we have to think about time, right? This is going to take a very, very long time to, train the whole community. And this is not possible given the time that we have with this new country. The 12 people that are randomly selected are obviously going to be less skilled than the people who are specifically selected to do their job. Okay, so 2 things that they drop. They drop that they are the judges are selected to be out of the population, and 2, they drop that the fact that these judges are the lead of the population, so they're more educated. Okay, and then they also drop the idea that they can easily be held responsible if they make terrible decisions, while the jury has jury protection by default. So if our judges are biased, your judges will also be biased too because you have one. So this is so what they're trying to say is that both sides are terrible, but what we're telling you is not only our side is much, much better in this case. Moving on to our second contention, which is lack of expertise. They say we're creating an institution that hopes to exist for a while. We also have amendments. Just because we don't have the jury system, jury system, it doesn't mean we're doomed from the start, right? They also talk about hope, but judge, hope cannot exist if your country is in turmoil. Focus on the country being new, right? New means relatively more unstable than a well-established country. We think that juries can exist in the future in the country when they have more money. But let's look at the status quo. The country is new, they do not have that much money, and therefore we cannot. They also say how the major point of trial is to make sure juries can get informed, which is good, but how is that better than not having it? You're literally just wasting time. You can get education elsewhere. They also say judges wouldn't be informed. We don't really understand what they're talking about, especially if the judges are, selected. And finally, they completely drop our resource drain, right? We talk about how you can invest in schools, roads, hospitals, things like that. You have to pay the jury, there's the opportunity cost, and you have to build more resources literally for the jurors. So for all those reasons, I'm so proud to oppose. Thank you.
Okay. Yeah. All right. Can everyone hear me? Good. Okay. My time will start in 3, 2, 1. Honestly, at this point in the round, if you're a tech judge, you should probably already drop C1 and C2 on the opponent's case, because for each of contention 1 and 2, I gave 2 responses in my LO, but we only saw 1 front line for each response for each contention. Even if you agree with all their front lines, even everything after that Jane told you, then you can still drop their contentions because of the fact that they just ignored half of our responses. I will be giving a lot of POOs if they try to give new responses to these responses in PMR, so don't mind me. Okay, at this point, Judge, you drop their whole point on checks and balances. Why? Because the government literally told you that the jury is only there for heavy criminal cases and civil cases and not equity cases. Thus, this isn't something like the Supreme Court. You're not actually changing the laws, right? They never responded to this response. Other than that, they also never responded to the fact that there are alternatives other than their POI, but unfortunately, POIs are not admissible. They never responded directly to the fact that deciding between whether a person is guilty or not, you're not actually changing laws and you're not actually changing equity cases by the opponent's definition. Other than that, Gov also goes for 3 main things, so we'll just win under 3 of those ballots. First of all, they say more people, less biased than judges. Again, this is simply not true. Why? Because we give you 3 reasons why they will be less biased than 12 people. They only respond to one of them. They try to mitigate that first one by saying, oh, we will train the jurors, but then they ignore our spike that says if you train the jurors heavily, you are a giant time sink. And not only that, you can't train them to remove their implicit biases, right? And best, even if you take their entire mitigation response, they also drop the fact that we said they are selected to be out of the population. They are the elite of the population in deciding what is right or wrong. This means they are the least biased out of the population. They also drop our third warrant, which is that they can easily be held responsible if they make terrible decisions, while the jury has jury protection by default, so they won't be held responsible at all. So on our side, you actually see more fair trials. What does more fair trials mean? Less people get wrongfully sent to jail. And then they tell you, oh, vote for us on long-term benefits, right? First of all, we solve long-term problems because of two of our three warrants for C1 and C2 are independent of being a new country. What are those? Which is specifically that first, all people who don't study law or phil lacks experience in the rules of evidence, right? They rely on narrative heuristics that no one day training could ever solve. And second, these jurors are new to the situation. They have no idea what's going on. And again, unless you cross apply their other arguments to this magically, they drop these responses. And you also should take that we definitely win under a new country because they never explicitly say why we don't. They just said, oh, you don't win under the long term. Thus, take us for the long term and especially the short term. And third, on education and government, we've already proven that this is terminally non-unique because you're better off just investing in schools, and just wrong because they never responded to the fact that in a criminal court or civil case, you decide either the person is guilty or not. You don't learn anything about how the government actually works behind the back. So in the end, Judge, you vote on us for quite a few reasons. Even if you think everything I just said is a complete wash, you can still vote on the fact that we have our resource strain argument, which was completely dropped. They never mentioned that as a new country, you need to be conserving resources. And as an older long-term country, you still need to be conserving resources because those resources, time, money, is very valuable. Every single hour can be used on something else. For example, education, healthcare, which can benefit the people much more than deciding between a criminal case, which already is decided because we already know what the laws is. And anyways, we are more likely to be more impartial in the first place. And even after that, even if you don't buy any of that, you can still buy the fact that being a juror is just annoying. It's just plain annoying. They gave a mitigatory response, but they don't actually respond to the argument. And with all that, I urge an opt ballot. Thank you.
Hello again, my name is Corwin Gana. I will be doing the third and final speech for the affirmation just to close off this round. Quick off-time roadmap. I will just be going over some very initial responses, talking about some new points that were brought up in during the opt block that under parley rules I'm allowed to respond to. And then I will be getting on to some voting issues or reasons why you, our wonderful panel of judges, should be voting for the affirmation. With that being said, I will start my time in 3, 2, 1. So firstly, we see from the opposition that a claim that our plan falls apart because we don't have funding and that a new country does not have enough money to be able to enact the plan. So first of all, Judge, I would like to point out that in parley, we have this thing called fiat, which basically means... Yeah, go ahead.
This was said in our first speech and no response was given in MG at all on the funding or anything related to money.
Okay, so I want to point out specifically the funding point that was brought up in your first speech was that it's expensive to have a jury and that this has harms to the country in other places, but it was never brought up that the affirmations plan is fundamentally flawed due to the fact that we don't have money to put this into the Constitution. So I'm responding to the point that was brought up in the second opposition.
Wait, pause. If this was never brought up at all, then you definitely can't respond to it because that would just be a completely new point.
No.
Money is definitely not responded to is what I'm trying to say. But other than that, judge's discretion, of course.
Yeah, of course, judge's discretion. I just do want to point out the point that since we don't have funding, we can't enact the plan with normal means and ways. It was the response to the normal means and ways thing that was brought up in opposition's second speech. And because of parley rules, we didn't have an opportunity to respond to that before it was brought up. And so this is my opportunity to respond to that. And now I am making this response, but obviously judge's discretion. So I will resume my time in 3, 2, 1. So back to this normal ways and means thing. The opposition doesn't outline how writing this into the Constitution would require more money. So because of fiat and because of the point that this doesn't actually take any more money, this point just doesn't stand. So we see that the affirmations plan is still very feasible. Now, in response to on to op case, in response to our response to their second contention, where we brought up the long-term benefits of having this Constitution in place, the opposition in their second speech brings up the fact that we can have a jury exist in the future and that it doesn't need to be right now. But Judge, this was not outlined by the opposition's counterplan, and there is no proposed mechanism as to how this would happen. I would remind you that the opposition's counterplan is to have 3 judges per trial instead of a jury. So this point that a jury could exist in the future also just doesn't stand. And now, just to reaffirm some things that we said in our speech, in response to their third contention, which was basically about how doing jury duty is annoying, the opposition claims that we didn't have a response to this other than that it was a small impact. However, I would just like to restate what my partner said, which was that sure, it's annoying to go to jury duty, but what's more annoying is to not understand the legal system that we are subject to. And then my partner brought up the example of what if you're convicted of a crime? It's very useful to have that knowledge of how like a courtroom works so that you can make better informed decisions. So with that being said, I would like to get onto voters now. So first voter then is on bias. And I would like to talk about basically 2 things in this round. Number 1 would be group size, and number 2 would be like the advisory of jurors. And so firstly, on this notion of group size, my partner provides a very simple link chain to explain this, but we basically say that the larger of a group that is making a decision, the less biased fundamentally that decision will be. And so just to kind of provide a better explanation for what my partner was talking about to really make it crystal clear for you guys. So if we have 5 people who are extremely like red opinion, right? And then we have 5 people who are kind of gray opinion, and then we have 5 people who are blue opinion. It stands to reason that a group of 12 of those people is going to have a less biased average opinion than an opinion of, say, 3 of those people who are randomly selected. And so we fundamentally see that group size, as my partner explained, decreases the amount of effective bias by, as my partner said, a factor of 4, as 3 people making a decision versus 12 people making a decision. That is 4 times the amount of people. So number 1, we see that group size is a reduction of bias. But number 2, if we're talking about bias specifically related to judges versus jury. So one thing, first of all, we see that these jurors are people, they have common sense, and they have decision-making abilities. But number 2, we also see judges aren't teaching jurors the entire law. Judges are there to advise jurors about what is and what isn't legal. And so fundamentally then we see that the judges are not wasting hours and hours of time basically turning jurors into, yeah, go ahead.
Your response, the fact that they are not wasting hours and hours of time, new response, like purely new. This isn't even like me like hallucinating.
Yeah, just judge's discretion, but the point about like the advisory of jurors was outlined pretty clearly in the first affirmation speech. So judge's discretion.
Oh, that's not what I'm talking about. I'm talking about you saying judges won't spend more, like we won't waste time, that argument.
I'm just cross-applying analyses, judges, but it's your decision. So I will resume my time in 3, 2, 1. So fundamentally then, the affirmation should win on the point of bias. We have provided numerous warrants. Number 1, that higher group size results in a reduction of bias. We have also talked throughout the round about how in a world where both worlds have more biased judges, if we're taking that and meaning that basically this bias point washes out, we still see that group size results in a reduction of bias, because if both worlds have bad judges, the bigger the group making a decision, the less biased it's going to be, as I have talked about. So second voter then is on long-term benefits. And so we see that the impacts of 200 years of prosperity outweigh a present basically impact. And so the affirmation talks a lot about the current negative impacts of maybe having funding problems or et cetera, like infrastructure problems. However, we see, as my partner explained, like chaos is always going to happen in the beginning of a country. But we would urge you judges to consider the long-term impacts and benefits of having this. So as we have explained, in the affirmations world, we have jurors and juries. And in the negations world, we have a panel of 3 judges. As I have already explained to you how the 3 judges leads to more biased decisions and the reduction of the power of the people and democracy, etc., I would urge you, judge, to consider the long-term benefits. We are aiming to have this country last for a while with its constitution. And so I would like to just point the judge back on the flow to all of the points made by the affirmation. That being the promotion of democracy, resulting in more power to the people and more social welfare. The presence of like an increase in checks and balances, basically meaning the power of the people goes up and the power of the government goes down as people are making more decisions. I remind the judge the benefits of like education, jurors learning hands-on from courtrooms. And so just for all of these reasons, I urge the judge to consider the long-term, maybe centuries of impacts as the biggest impact of this round and a vote for F. Thank you.
Thank you. Good debate.
Yeah, thank you
Yeah,
guys.
thanks, guys.
What
Yeah.
school are you guys from?
Princeton High School.
Or sorry, like where is that is what I mean.
Princeton. It's in Princeton, New Jersey.
Okay.
Like the university.
Wow, so that's cool.
Well, like I feel like the smartest kids in Princeton don't go to Princeton High School because like they go to private schools.
Yeah.
Yeah.
Well, you guys are doing pretty good, so
Thanks. We'll see you in a sec.
Yep.
yeah.